most of our listeners are either appellate lawyers or trial lawyers who dabble in appellate law, and they love tentative rulings and they love focus letters. And I've seen more and more courts moving towards either. Um, from your years on the bench, can you give any insight as to why certain courts are not giving tentative rulings or focus letters, or what kinds of cases are not suitable for tentative rulings and focus letters?
Well, I think it's different between the two because I think a case where the issues are complex and if you go one way, it's going to involve three different levels of analysis, and if you go another way, it's going to be three different analyses. Those are great for focus letters because the court can say, "Here's the central thing I'm grappling with." And a lot will turn on what the answer to that is. And that's a great area for focus letters. The other area where I've seen focus letters be incredibly helpful is where the record is not clear on some point. And often that does happen. And it's a way to get clarification of the record in advance because the lawyers are ready to speak to it. The issue with tentatives is they are great for the lawyers because it allows them to know, just as, when you go into law in motion and you have a tentative ruling, you know when you're going to be speaking, if nothing else, but you know how to focus yourself, is that sometimes in oral argument, it's surprising that we hear things that we didn't expect to hear that actually can turn things around. And if you give a tentative ruling, excuse me, if you give a tentative ruling, you may never hear those things because everybody goes down the path that you thought you were going down, and there's less opportunity to see that turning that you didn't see. And so, I think there are good arguments on both sides. I resist the explanation that some people give that the courts just don't want to be bothered to do the extra work, because in my experience, that's not what's driving it. But I think that there are some people who are just comfortable with focus letters, but not with tentatives because they're afraid they'll lose something. And some people who think tentatives are just fine. And it's going to be up to the panel where that comfort level is. Huh. And I think that will change over time too, as the panels change. There are a lot of vacancies in the second district, and things may change when there are new appointments in terms of the approach to that issue.
I have to say, I'm surprised to hear you say that sometimes you're surprised in oral argument, because the sense I get from listening to MCLE, I do a lot of appellate MCLE, and I hear appellate justices or retired appellate justices say that 95% of the time, oral argument does not change the outcome of the bench memo that's been prepared, and that in many cases the parties have been better served waiving argument. So it's great insight. Thank you for sharing that.
You're welcome. And I mean, those statistics are right that, 90 to 95% of the time you walk onto the bench thinking the same thing you think when you walk off the bench. But there were enough times in my time on the court where a lawyer brought an argument in a certain way that caught me, just, made me say, that's a different way of looking at it than the way I was thinking about looking at it. And I want to go back and think about that some more. Oh. And those are important moments.
Yeah, I've heard Justice Hofstadt share a similar perspective on oral arguments and focus letters, saying to the effect that what you just said, Justice Zelon, that one of the beneficial things about oral argument can be when a good advocate puts the entire case through a different prism or a different theme, and can make the justices see something that maybe was not well presented, maybe not well presented, but just just didn't come across as well in the brief, or they found a new way to put it. And a focus letter would just make the advocates laser pointed on that one issue that was addressed in the focus letter, and you would lose that important persuasive vehicle of being able to put the case through a different theme or prism.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.